Proceed.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the Court. My name is Josh Halpern, and I represent plaintiff appellant Damon Landor, who's here with us. My client took a religious vow never to cut his hair. When he arrived at Laborde Correctional Center, he had dreadlocks down to his knees and a copy of this court's Ware decision in his hand, establishing his right under RLUIPA to honor that sacred oath while behind bars. But the prison officials didn't care. They tossed this court's decision aside, they strapped Mr. Landor down, and they shaved him completely bald.
The facts, we know the facts, and I'll agree with you, they're pretty deplorable, but isn't the question before us whether Tanzan unequivocally overruled our Sossaman decision?
That is the question before you, and the facts are important, because if it didn't, then prison officials can do precisely what they did here in future cases, toss this court's decisions aside and violate RLUIPA with impunity. Tanzan holds that that is not appropriate relief. Tanzan held that RFRA's identically worded remedial provision clearly authorizes individual capacity claims. This court in Sossaman said that RLUIPA's identically worded provision does not authorize individual capacity claims as a matter of statutory interpretation and constitutional avoidance.
But the briefing here was very good, and you know where the argument's going to go. I mean, Sossaman, if it's predicated on federalism because of a spending clause argument, nothing in Tanzan undermined that, right? You do have identical text, and you clearly, I agree with you, have identical purpose to vindicate free exercise rights, especially in prisons with no other relief's going to work. But it's hard for our panel, as opposed to the full court or the Supreme Court, to say that the reasoning behind Sossaman has been abrogated, right?
So a few points on abrogation, Your Honor. Sossaman did not resolve the constitutional question of whether Congress can impose liability on employees of funding recipients. It reserved that question and interpreted the text and held as a matter of constitutional avoidance that RLUIPA's language, which is identical to RFRA's, does not clearly authorize individual capacity claims. These two statutes have always been construed in lockstep, and the Supreme Court has told us that RFRA's identical text clearly authorizes individual capacity claims. That abrogates Sossaman because constitutional avoidance is only triggered when there is more than one plausible construction of the statute. Tanzan teaches us that there is not more than one plausible.
Has any circuit, including district, yet said post-Tanzan, unanimous Supreme Court opinion, that the spending clause contractual federalism logic is invalidated? Is there any court that's yet said what you're asking us to say?
There are district courts, but let me say this is the first appeal since Tanzan in which this question is fully briefed. So this is a rare case that presents this court with a unique opportunity to address a vitally important question of statutory interpretation with profound implications for religious liberty that has consistently evaded appellate review since the Supreme Court's decision in Tanzan.
And it may be persuasive, but I suspect you're also just as excited to be persuasive to the full court if our panel decides that we don't have the authority to do it, right?
En banc is never a sure thing, Your Honor, and we don't think you need to go there because, as I said, Sossaman did not resolve the constitutional question, it reserved it, and constitutional avoidance only applies if there is more than one plausible construction of the phrase, any other person acting under color of law.
Multiple other courts did sort of go down the direction, the reasoning that I'm trying to emphasize here, which is states were never put on clear notice by RLUIPA that their officials may face individual damages, right?
Yeah, lower courts were led astray by a misplaced constitutional concern that Congress lacks the authority to impose liability against non-recipients. That's directly contrary to the Supreme Court's decision in Sabri. But I will say that Congress gave clear notice of its intention.
But that's a little quick to say that and then move off, because Sabri is a criminal case premised on spending clause. Government monies need to be protected from bribery. It's sort of far from this case.
Well, Sabri, it's true that the statute at issue was an anti-bribery case and it implicated the criminal law, but the principles that Sabri articulates clearly go beyond bribery. Sabri upheld the relevant statute in two steps. First, that the spending clause broadly empowers Congress to attach conditions on federal spending, and that the necessary and proper clause empowers Congress to prevent non-recipients from interfering with the execution of those conditions. RLUIPA is constitutional under a straightforward application of that test because RLUIPA's liability regime clearly is designed to prevent employees from interfering with its substantive commands. If Congress was not empowered to impose liability, we would have rampant violations of RLUIPA like the one we have here, where state employees—
When you say district courts, I just want to make sure I don't forget to ask, what is the best district court that has actually post-Tanzen said just that?
So that there are a few district courts in the
Just
city.
give me the best.
I actually don't have the names of the district courts off the top of my mind. I apologize, Your Honor.
Well, you can get that before you come back up. I'm sure it's in your brief.
I'm not sure that it is.
But when you say there are multiple district court opinions that have, you must have been thinking of something.
A few in the Sixth Circuit, yeah. The district courts in the Sixth Circuit have come out. Some have said that circuit precedent has been abrogated by Tanzen, and some have not. I'm not aware of a district court in this circuit that has. I will say that if Your Honors are looking for a template to resolve the case, I would direct the court to our brief, which I think does a good job on that score. But to Your Honor's question about Sabri, this case is easier than Sabri because RLUIPA only imposes liability against employees of the funding recipients who consent to the liability regime when they knowingly accept employment with a funding recipient. And in that respect, RLUIPA is not unique. Congress frequently imposes liability on employees of funding recipients to ensure its spending clause conditions are being honored and not undermined by the employees of the recipient. It did that in EMTALA, the Emergency Medical Treatment and Active Labor Act, and it did that in Title X, the statute at issue in Rust versus Sullivan. Now, turning back to Your Honor's question about abrogation, none of these arguments were before this court in Sosaman, and that's why in footnote 36, this court expressly reserved the possibility that Congress might indeed possess the authority to impose liability against employees of funding recipients. And that was a prescient reservation. The parties did not mention Sabri, and they didn't mention the many other spending clause statutes in which Congress has utilized liability to ensure that its conditions are being honored rather than undermined. Sabri's language, reserving the constitutional question that animated its avoidance holding, is essentially an invitation to subsequent panels, particularly in light of Tanzen, to revisit its avoidance holding. And so, taking the circumstances together, we actually don't think this is a particularly difficult question on abrogation. While it is always a big step to declare that circuit precedent has been overturned, there is simply no way to square the Supreme Court's decision in Tanzen, which held that RFRA's identical language clearly authorizes individual capacity claims, with this court's decision in Sosaman that RLUIPA's language does not. Those two are intractably in tension, and Tanzen must control. If I might, Your Honors, I'll turn to the other side's forfeiture arguments because that is sort of the key theme of their brief. So we think that this issue is preserved for appeal for the simple reason that the district court dismissed the RLUIPA claims in full on the theory that RLUIPA does not authorize damages against defendants in any capacity. Under settled circuit precedent, we were entitled to challenge the basis for that decision on appeal, regardless of whether we filed an opposition to the defendant's Rule 12 motion. That rule makes particularly good sense in a case like this one, where the question presented to you is one that this court is uniquely best positioned to address in the first instance. But even if, I guess one other point on forfeiture, they also claim that we didn't sue them in their individual capacities. They say that a few times in their brief. And I just want to stress that the caption of the complaint says that the defendants are sued in their official and individual capacities. They acknowledge that repeatedly below to the district court. And on page 6 of their motion to dismiss, they said, the RLUIPA claims are brought against all defendants, including Myers and LeBlanc, individually. It's actually quite shocking that the defendants would represent repeatedly to the trial court that the claims are brought against them individually, successfully move to dismiss those claims, and then turn around and tell this court that the individual capacity claims never existed in the first place. I think that underscores the lengths to which the defendants are going to avoid the merits of this question, because Tanzen is so clear and because the misconduct here is so egregious. But this court should not give the other side a free pass. Even if you disagree with us on the preservation question, you certainly have the discretion to reach this issue, and you should do so because, respectfully, if you don't, prison employees will continue to do what they did here. They will toss this court's decisions aside and violate RLUIPA with impunity. What happened to Damon Landor is not some isolated occurrence. On pages 11 to 12 of our reply brief, we chronicle multiple examples in which Louisiana prison officials are alleged to have violated the rights of religious prisoners and shaven them bald even after this court's Ware decision. What those cases show, and what this case shows, is that without a damages remedy, there is no deterrence, and RLUIPA becomes unenforceable in the many cases where Congress clearly intended it to apply. This appeal presents a rare opportunity to remedy that wrong and to restore the deterrence that Congress established in RLUIPA, because if we
reiterated, maybe in unpublished opinions, but Sossaman's been reiterated both before and after Tansen, correct?
That's right, but never in cases where Tansen was fully litigated in a case like this one, where
I'm sure you know them all. Laverne, Stetson. So you're saying the arguments just weren't made in those cases?
I can't say that with total confidence here before you because I didn't review the briefing in all of those cases, but I will say that this court has never written in a decision that Tansen does not abrogate its prior decision in Sossaman, and so that question is surely open to your honors.
Two questions. I mean, there's an amicus brief, at least one, Professor Laycock, supporting you, correct?
Yes.
Are his arguments fully aligned with yours?
They are, and they actually add a great deal of substance on the statutory text, which makes sense because he was one of RLUIPA's chief architects. And if I could, just returning to the point about why Tansen is clear on the question of appropriate relief. So Professor Laycock points out that if this statute were intended to only authorize injunctions, there would have been no need for Congress to define government to include official or any other person acting under color of state law, because the injunction against the institution runs necessarily against the individual officers, and that would all be surplusage if this were an injunction-only statute. Congress named the individual defendants here because it intended to create a damages remedy against them. And that fits neatly with the two core reasons why damages are appropriate relief in individual capacity cases, because damages are the presumptive remedy when a state official violates federal law. And in cases like this one, where it's damages or nothing, appropriate relief means damages and not nothing. Congress would not have used the formulation appropriate relief if it intended to create no relief at all.
Fine in prison for?
That is not within the four corners of the complaint, Your Honor. My understanding is that it was a drug-related offense and possibly parole violation.
Parole violation?
Yeah, the relevant tenure in prison here only lasted 5 months. And my client arrived to Laborde Correctional Center with just 3 weeks left on his sentence. And the two prior prisons that he had been in allowed him to wear his dreadlocks. Again, he got there, dreadlocks down to his knees, a copy of this court's decision in his hand. The freedom not far out of sight, only 3 weeks away, but the defendants had other plans, and they tossed this court's decision aside. They strapped him down, and they shaved him completely bald. And the reason I reiterate the facts, Judge Higginson, is because what the facts underscore is that something has gone badly wrong in the RLUIPA jurisprudence. If the defendants can do this with impunity, and they can do it repeatedly, then this court's intervention is past due. The question of whether circuit precedent has been abrogated by the Supreme Court is what this court said in Bonvillain, a judgment call. But I would urge the court to let your judgment be informed by the facts on the ground, and the facts on the ground are truly unforgivable. What happened to Damon Landor should never have happened, and I would submit to you there's a substantial chance that it may not have happened if RLUIPA actually had the deterrent force that Congress intended to endow it with through a damages remedy.
Until arguments like yours are made elsewhere, it's still true that every other circuit that's addressed this would still not award individual damages at the moment, correct? So if you were persuasive, we would be splitting with other circuits. Every other circuit that's
I don't know that I would call it a circuit split. Until the other courts say that Tansen does not abrogate prior circuit authority, there's no split. This court is truly the first to address the legal question of whether Tansen changes the landscape. And this case presents a rare opportunity to address an issue that has consistently evaded appellate review in the 3 years since Tanzan was decided. That's why there are dozens of religious organizations and leading scholars signing amicus briefs urging this court to recognize a damages remedy, because without one, the facts of this case show that state employees can toss judicial precedent aside and violate the congressional mandate with impunity. I see that my time has nearly expired. If I could reserve the rest of my time for...
I don't see many papers over there, but if you know the district court opinion that you say held exactly as you described, if you can find that, I'd be interested.
Sure, I will search. Thank you.
Thank you, counsel. Ms. Glazer,
Yes, Your Honor.
you may proceed.
Sorry, I brought too many papers up here. Thank you, Your Honor. Phyllis Glazer, on behalf of the defendants' appellees, James LeBlanc, Secretary of the Department of Public Safety and Corrections, and Marcus Myers, Warden of the Raymond Laborde Correctional Center in Avoyelles Parish. First of all, I'd like to ask that you all expressly affirm the dismissal with prejudice of all of the claims that were waived by the plaintiff on appeal. So in his complaint, which was very long and...
Well, before you ask us what to do and talk about waiver, why don't we start just with the points I told him not to start with, the facts of this case.
Okay.
We have to take, tell me if I'm wrong, we've got to take as true that he was waiving a Fifth Circuit decision at the prison officials, your clients, and that they threw it in the trash can.
Well, one
unlike
of
the two prior prisons.
Right, that was
Told him that
the
they were going to
allegation.
cut off his dreadlocks, and he was just a few weeks away from being released. All those facts are ones we have to accept as true.
Correct. And I wasn't disputing the facts. There's no dispute about
But doesn't that fall squarely exactly in what the Supreme Court unanimously said in 2020 in Tanzan? Specifically referring to the context of prisons where injunctive and declarative relief are not likely to protect them. Isn't that exactly why they said there has to be individual damages as a deterrent in the RFRA context?
in the RFRA context.
No, so yes, that's exactly the purpose. And how is it different just because this individual happened to be in a state prison from a federal prison?
Yes. And, I mean, he's suing under RLUIPA, not RFRA. And RLUIPA is not RFRA, even though the text of the statutes is the same. RFRA was...
Government officials can flagrantly violate his free exercise rights, but because they're state officials, they don't face damages, but they do now, according to the unanimous court, they're federal prisoner officials. Is that the position you're asking us to continue with?
No, of course not. The question isn't what are state officials allowed to do. State officials are still subject to suit under 1983 for individually violating clearly established First Amendment rights, including free exercise rights. That's still an available remedy, as evidenced by the fact that the plaintiff sued under the First Amendment and named the defendants in a First Amendment claim for damages. So it is. RLUIPA has a higher standard, a higher burden of proof. It shifts the burden to the state and so on and so forth. But that doesn't mean there's no remedy, and it absolutely does not mean that the state is taking the position that state employees can flagrantly violate the rights of individuals who are incarcerated. That is certainly not the position that's being taken. The question is whether the United States Congress has the authority under the spending clause to impose individual liability under a spending clause statute against an individual who is not the recipient of federal funds. That's the question. Every court to have considered this question, including this one, agrees that Congress does not have that authority, and individual liability under a spending clause statute is not allowed.
Any court reiterated that post-Tanzan?
Yes, including this one. Well, this court has upheld that there's no individual claim for money damages under LUPA, right, adhering to Sossaman,
The
which was...
circuit court articulated the rationale you just asserted, which is that Tanzan didn't abrogate.
Believe the Ninth Circuit has, but I have to check.
But that would be a big thing to have to check. You think the Ninth Circuit has or hasn't? Is
I
it?
think the Ninth Circuit has reaffirmed that you cannot, there's no individual liability under RLUIPA post-Tanzan.
And that's in your brief?
I think so.
I don't remember that it is, but.
I thought you were going to give me a page number to help me.
Well, keep on with your argument. If they have, it's going to be easy to find.
Anyway, that's the question. So this court's Sossaman decision was based on that spending clause analysis, which was based on an 11th Circuit decision, and every court that looked at it has since then has followed it. Tanzan didn't even mention the spending clause, which is unsurprising considering that RFRA is a Section 5 of the 14th Amendment statute, and RLUIPA is not. So they're not the same. And these principles of sovereign immunity that are require the court to look very closely at the statute are still in play because you can't take the state out of the mix. The state is the recipient of funds, and the state's receipt of those funds is conditioned on compliance with RLUIPA. And so you can't take the state out of it. The statute itself, as written, as in effect, implicates the state's sovereignty. And so the Pennhurst analysis and all those strict interpretation of the statute rules that were applied by the Supreme Court in Sossaman still apply here. You can't pretend that the state's not involved in this economic, this distribution of funds. You can't take the state out of it, pretend it's not there simply because they're suing individuals on appeal. They're dropping everybody else. I mean, originally it was the state officials in their official capacities, and all the whole litany of available remedies. That's what was in this massive petition, and so, but now they're just focused on this one claim, and Tanzan did not overturn this court's ruling in Sossaman.
You're saying Mr. Landor has another available remedy?
Sure.
Add one?
Yeah, well, he sued under 1983. Now, do I think that he stated a claim under 1983? No. But did he have another available vehicle? Yes.
Let's do it this way. Let's take these facts. You don't deny any of the facts.
Well, not as pleaded. I mean, we're accepting them as true. I haven't done it.
Accept those facts as true. What's the claim? What claim could he have brought?
Well, he could have brought a 1983 First Amendment claim against the warden and the individuals who held
And
him.
accepting the facts as true, that means he would have prevailed on that claim.
No, because that would have stated a First Amendment claim but not overcome qualified immunity. But
Well, you're telling me he has a remedy, so I'm trying to figure out what it is. We agree on the facts. We agree on what happened. You're saying he has a remedy. I want to hear what that remedy is.
well, okay. I'm saying that he has another vehicle for suit. I don't think that he does have a remedy, which is why we asked that
He's
this.
not interested in just filing feudal lawsuits. Tell me the one that he wins on these facts, because we all agree the facts are egregious.
He doesn't win on these facts.
Oh, he doesn't win.
He doesn't win on these facts because of precedent. Not because precedent is fair or because precedent is righteous, but because precedent is precedent, we have to follow it. That's
So you're not saying Sossaman's correct.
emotionally,
You're saying it hasn't been unequivocally overruled.
absolutely. That is
All you're saying.
correct.
You're trying to defend the correctness of Sossaman.
Right, and in fact, the point about Sossaman, about this court's Sossaman decision, that was the focus of Mr. Landor's briefing was the text, the identical text of RLUIPA and RFRA on these points, right? The appropriate remedies.
I
And stuff.
understand if they turn around, if we were to follow your reasoning and then they file an en banc petition, would you not oppose it? Because
course.
you think Sossaman's actually not correct, it's just not yet been overruled?
I think Sossaman was correct on the spending clause issue. I think Sossaman, and I have no case. I did the research. I mean, I cannot find a case, not a district court case or a court of appeal case in the entire country that disagrees with that conclusion from Sossaman, that a spending clause statute can create an individual capacity claim for money damages. That is there's no disagreement. And so, no, I don't have any basis to disagree with this court's ruling.
Hansen's 2020, but he is pointing at Sabri. I mean, 666, the statute involved in Sabri, applied to fund recipients as well as to individuals.
Yeah, but Sabri didn't, first of all, it didn't involve a state agency. That was a municipality. Secondly, but there is still that sovereignty issue. The statute in Sabri unequivocally imposed criminal liability for bribery. The language of RLUIPA, even if you think appropriate relief means money, is not as unequivocal as that. That was one of the points that was made. The other thing is, it's a criminal statute that was specifically designed, like you said earlier, to protect the federal funds that were being distributed across the board. And so it didn't. The receipt of the federal funds wasn't contingent on anything. Everybody was getting federal money, and if you got more than $10,000 of it, your people would be subject to federal criminal prosecutions if they made or accepted bribes. And that was it. Now, this is not anything like that, and every court to have considered this very Sabri argument has rejected it whole cloth. This RLUIPA is fundamentally different than the Sabri criminal statute. RLUIPA conditions the state's receipt of federal funds on.
Have a constitutional bedrock that's different. I don't think it's radically different, but it looks to me like Congress in RLUIPA and RFRA is doing the exact same thing. We want to resurrect pre-Smith case law to make individual damages against government officials that violate people's free exercise rights. Exact parallel, using the precise same relief language.
And
you're not disagreeing with that. That's exactly what Congress wanted to do.
Right.
You're just saying Congress constitutionally can't do it.
correct, because that's what this court has said and every other circuit to have considered it. Specifically RLUIPA. I mean, those cases that are cited in our brief are RLUIPA cases where they say that, not...
Every case that's on page 15 of your brief, every case is pre-Tanzen.
Correct. Because Tanzen doesn't have anything to do with the spending clause, so there would be no reason for there to be a whole nother litany of cases. I mean, Tanzen pertains to RFRA, to a Section 5, 14th Amendment legislation that is interpreted without regard to the state's sovereignty, without in a different way than the spending clause legislation at issue is. And so you have to, the spending clause legislation is evaluated under the standards that this court and then the Supreme Court looked at in Sossaman, and those cases have not been overturned, certainly not unequivocally, which is what the requirement is for y'all to overturn an earlier case, an earlier panel decision.
Something opposing counsel brought up. Are you still contending that Landon didn't sue the prison personnel individually? When the complaint and the caption clearly...
The complaint, the caption of the complaint, only the caption, nowhere in the 100 and something paragraphs of the body of the complaint, it's not in there, it's only in the caption, said that they're sued individually and in an official capacity, a fact that we have admitted throughout these proceedings. Whether a claim has been stated against them individually is a different thing. It is certainly not clear, if you dig through to the RLUIPA claim, that these two were sued individually under RLUIPA. And it's certainly not clear that those two were sued individually under RLUIPA for money. They were sued under RLUIPA as officials alongside the state, and the argument, and there was a an improperly placed legal argument inside of this complaint. The argument in the complaint was that the Supreme Court's Sossaman decision should be overturned because the state should not be given sovereign immunity from the suit for money damages, and that was the argument. That's the argument that was in the complaint. So, no, it is, even though they use the word individually in the caption, it is not in the body of the complaint, and it is nowhere clear, or there's no short and plain statement in this massive complaint that they are being sued individually for money under RLUIPA. The best we can do with a shotgun pleading like that, we as the defense attorneys, is move to dismiss it. And that's what this court's precedent says about shotgun complaints like that. I mean, they sued the state of Louisiana under 1983. They asked for injunctive relief under state law. We have no option but to sort of line item these things out in a massive motion to dismiss that, I should mention, was not opposed in any way. There was no offer from counsel to say, oh yeah, we really meant to clearly sue some individuals under RLUIPA. No, nothing, not a word. It was 2 extensions, a improperly filed amended complaint that did absolutely nothing substantive at all, and that was it. And so, no, it was not clear in the complaint that they're suing individually. That they were being sued individually. It's clear now that that's what they intended, but, you know, it was just in the caption. And the Supreme Court says, oh, this was way back, that it's the official and personal capacity distinction is not a, you know, pleading formality. It's substantive, and there is a difference between those causes of action. There's difference between those assertions, and there was not. Anywhere in that massive complaint, there was no distinction. There was no distinction made, and so, you know, no. And on that point, because the district court resolved this question on the basic question whether or not you can even have a right of action for money damages under RLUIPA, the court didn't examine. We didn't argue, and the court didn't examine whether or not an actual claim had been stated, as would be in a typical, a typical Rule 12 motion. We didn't even get to that. And so that, if you want to talk about an issue that was not briefed or argued, that was one of them, whether or not a cause of action had been stated under RLUIPA, bearing in mind, of course, that if the court decides to reverse, that they would be entitled immediately to raise qualified immunity from an individual capacity claim, and, you know, briefing would start anew. But in my last couple minutes, I do want to ask that all of the other claims that were brought, which were dismissed, that those dismissals be affirmed. So that's all the 1983 claims, all the state law claims, the demands for declaratory injunctive relief and other further relief that is equitable, all claims against the State Department of Public Safety and Corrections, and that all of those were brought and were dismissed and should stay dismissed because they were not challenged. The dismissal was not challenged on appeal. The only claim that was challenged was this individual capacity claim for money under RLUIPA.
So your legal argument, let me just, to understand it, is Congress lacks the authority to do this, or Congress may have the authority, but they would have to give clear notice to states that they're imposing Tanzan liability?
I think, well, in this case, I think it would probably be both. Congress lacks authority to create a cause of action against anyone who is not a recipient of federal funds, or
Congress says, states, if you want federal money to go into prison, your individual prison officials are individually liable if they violate by handcuffing someone and cutting off his hair against his religion.
that may be sufficient if there's clear notice under those standards. I don't know of any statute that's actually done that, so I'm not sure.
Actually, does this record reflect whether they were disciplined in any way?
The warden, no, this not in the complaint. It doesn't. And just so we're clear, the secretary of the department was not there. He's just the secretary of the department. He wasn't there in Cottonport at the prison. Just so, I mean, yeah. So, oh, and as to the second part of the question, if they put it in the statute clearly and unequivocally that there could be individual liability, that may be enough to satisfy the Pennhurst test, like we know what we're getting ourselves into part of it. But I don't know if that's going to answer the first part of the question about whether Congress has that authority at all. I don't know. I mean, they exceed their authority all the time, and I just haven't looked at that particular question because it wasn't at issue here.
Would it be contingent upon the receipt of federal funds?
By the state, 100%, yes. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. Just a few quick points. One point on why this is within Congress's constitutional authority, another on abrogation, then a quick note on the spending clause, and finally, I just want to touch on free exercise claims through 1983, which the other side says is apparently sufficient. So, starting with why this is, the other side says this should have been sufficient for Mr. Landor, though they also say he would have lost under that claim. So, but just starting with why this is within Congress's authority. So, Judge Higginson, you asked for other circuit court authority. Judge Sutton's decision in Haight versus Thompson, at the very end, he emphatically rejects the logic of this court's Sosaman decision, and he says that would be the holding of Sosaman that would exceed Congress's authority is contrary to numerous spending clause cases from the Supreme Court, and that it would clearly be within Congress's authority to impose liability on employees if Congress spoke with sufficient clarity. Now, he was operating in the shadow of the Supreme Court's Sosaman decision and without the benefit of Tansen, so he concluded that the statute was insufficiently clear.
I know you want to watch your time, but he's still saying Dole, for example, has to be met.
Absolutely, and I wouldn't dispute that. Yeah, that is the canonical test for all spending clause legislation. Yeah.
Where's the clear notice here?
The clear notice here is inappropriate relief against the government defined to include official or any other person acting under color of state law. And I can rehash those arguments. I feel like we've been through those.
Is she right that the Ninth Circuit post-Tansen? Are you familiar with the Ninth Circuit?
I'm not aware of that. I do know that the Ninth Circuit just appointed counsel in an appeal to revisit this question specifically. So they're certainly open to revisiting the question. But then on abrogation, Sosaman did not resolve the constitutional question. It avoided it. And it did so explicitly in footnote 36, this court's Sosaman decision, when it said it might well be the case that Congress can impose liability against employees of funding recipients. Now, another reason that decision should be abrogated is a reason that Professor Laycock points out in his fine amicus brief, which is that, and I think this speaks to the quality of the briefing in Sosaman, the court was not alerted to Section 5G of RLUIPA, which expressly forecloses reliance on constitutional avoidance by requiring that the statute be construed to the maximum extent permitted by the Constitution. And I think if that provision were before the court, we might have seen a different outcome. And so just finally, the other side says this is a spending clause statute and every application of the spending clause somehow implicates state sovereignty. That is simply not true. For a century, the Supreme Court has said that spending laws legislation is perfectly consistent with state sovereignty when states have the choice to accept or reject the funds and the conditions attached. Sovereign immunity is implicated in spending clause cases only when Congress seeks to extract a waiver of sovereign immunity and impose liability directly against the sovereign. That was the issue in the Supreme Court's decision in Sosaman, but that is not an issue here because we are suing the defendants in their individual capacity. So sovereign immunity has no application or implications for this case. And if I could, just the distinction between the Supreme Court's Sosaman and Tansen decisions is not the authority under which Congress passed RFRA and RLUIPA, but the capacity in which the defendants were sued. And you don't have to take my word for it. You just have to read those decisions. In Sosaman, the court says damages are inappropriate against the sovereign by virtue of sovereign immunity. And that's consistent with the Supreme Court's precedent under Section 1983, which held that you cannot use 1983 to sue the sovereign in its official, or defendants in their official capacity. Tanzan, on the flip side, held that damages are appropriate relief in individual capacity claims because damages are the presumptive remedy whenever a state officer violates federal law, and because in a case like this, where it's damages or nothing, appropriate relief means damages, it doesn't mean nothing. And Tanzan distinguished Sosaman, and it didn't distinguish Sosaman as a spending clause case. It distinguished Sosaman as a case about sovereign immunity, because that was the question presented to the Supreme Court. Now, this court is in a rare position, because this is truly the first appeal to fully brief the question of whether after Tanzan, RLUIPA clearly authorizes individual capacity claims for damages. We would urge the court to take the lead on this question, to get the right result, and to set a precedent that will pave the way for other plaintiffs in Mr. Landor's position.
We're going to speak to 1983.
Yeah, yes, Your Honor. Thanks. I appreciate the friendly reminder. So, yes, the point about free exercise claims being funneled through 1983, to me is a non-starter because Congress passed not one, but two statutes to repudiate the Supreme Court's free exercise jurisprudence and to go beyond the free exercise clause. The RLUIPA standard is more demanding. It requires accommodation. A prison can't just invoke abstract claims about security. It needs to accommodate someone like Damon Landor, who has had honored a religious vow for 2 decades and is going to be released in 3 weeks. Maybe they get a free pass under Employment Division versus Smith, but not under RLUIPA, and that's why Congress passed this statute.
Did you find that Sixth Circuit District Court opinion?
And I wanted to start there, Your Honor. I'm sorry. We did not cite it in the brief, and I don't have it on hand, but we're happy to file a 28-J letter.
That's all right. We can find it.
Okay.
You don't have to file.
Thank you. We'd ask the court to vacate and remand.
All right, thank you. The court will take this matter under advisement. That concludes the matters that are on the docket for oral argument today, and we are adjourned.